Before we take questions, I just wanted to introduce you to two people who are going to join Chetan on the panel, Chetan and Minesh on the panel. The first one is Atul Shah. He's a solicitor who ran a private practice in Harrow for over 25 years and is now a consultant solicitor. His clients range from individuals to top corporations. His approach is always with pragmatism, honesty, service to clients being the first and paramount consideration. He brings a wealth of experience in areas which include will making, probate, powers of attorney, estate planning, social care, landlord and tenant, and court work. Our second panelist is Ed Robinson. Ed is the co-founder of Keystone Probate, which is a firm which specializes solely in probate. Ed has 20 years of experience dealing with a large variety of estates. His experience includes working at Deloitte in the past. So without much ado, let me just hand you over to take questions. I think the first question, Sandeep, if you can relay that. Before I actually do, sorry, there's one thing I need to explain to everybody. There were a couple of questions and comments which we saw in the chat relating to with inheritance tax. I would like to ask those questions were actually very well covered in our inheritance tax session last Sunday, which is now also on YouTube. So if anybody has any questions on inheritance tax, please have a look at that video on YouTube. I think most of those questions will be answered. So without much ado, Sandeep, can you ask the first question, please?
Sure. Just before I ask the question, someone else has just pointed that out. Can they have the slides? Again, same thing. You get them on the YouTube. So just to reiterate, so we don't need to cover that. So first question, actually, I'm going to go to Chetan. What happens if you have bank accounts, more than one bank account with over £50,000 in them?
The banks are likely to require you to get probate, as long as the accounts are not in joint names.
Okay.
Excellent.
All right. This is a question for Atul, if I can, because it relates partly, again, Sandeep had covered this in his will session. If you have made a will in the last 10 years, do you still need to review and revise this will on a regular basis? And I think the answer when we had that session was yes, but perhaps just a quick answer for that, Atul.
Okay, thanks everyone. The will remains valid. So the one you have made is still valid, provided it follows the laws for making a will properly. But in 10 years, a lot of things change. Tax laws change, rules change, family changes. And as a result, it would be wise to review the will, see what changes are needed or required, and then to make a new one if that is the case. Hopefully that answers.
If I can just add to that,
Sure.
I would normally suggest reviewing your will every 5 years to see if any circumstances have changed, or if there are serious upheavals in the tax law, which we are quite likely to have fairly soon.
Mm-hmm. Okay.
That's a big comment, Chetan.
The government will need money.
That's it. All right. So question to Ed Robinson. Can probate in one country be used for assets in another? Example, a probate granted in the UK, can it be used in India, Kenya, etc.?
There's two answers to that. Is that basically if it's a Commonwealth country, such as Kenya or India, the country in question will usually ask for it to be resealed depending on the amount of the assets. So that is going through a new legal process in the country where you're trying to obtain the assets. But with other countries, for instance, the US, again, it depends on what the risk appetite of the financial institution is. For instance, in the US, we've recently managed to get a hold of about £80,000 worth of assets by just producing a UK grant of probate. But another financial institution won't accept it for 10,000. So it varies, but if it's an old Commonwealth country, then they may accept it, but they may require it to be resealed in their jurisdiction.
Thank you.
Right. Chetan, question for you. Very simple one, I think. What is a codicil?
Sorry, a codicil is where you haven't made a completely new will. You just change parts of the will. So, for example, you may have changed the names of the executors. You've left your existing will in place, not revoked it, but just changed parts of it. That's called a codicil. It's executed in the same way that you would execute a will.
Okay.
So the formalities need to be completed where it's witnessed by 2 witnesses and signed, etc.
Right. Thank you.
Can I just add there, it would be wise to make a new will if you're going to make alterations and changes, because sometimes codicils can confuse what the terms of the will are by having 2 documents, the will and the codicil. Thanks.
And sorry if I just interject there, whatever you do, do not write on the original will. That will invalidate it.
Mm-hmm. Thank you. Shandip? I think we may have lost Shandip. Can I just take a quick second question on this, please? Ed,
Yep.
How long does a grant of probate or letter of administration stay valid for? Are there any circumstances when these can be changed or whatever?
Well, generally it's valid for basically the life of the executors. So it's valid for as long as there's an executor continuing to live or an administrator in the situation of an intestacy. Also with the executorship, as Chetan pointed out, is that if the last surviving executor passes away, and basically they have a will that's proved in the courts and a grant is issued for their estate, then their executors can then carry on the role of the executors of the previous estate through what they call the chain of representation. So it's effectively it lasts as long as their lifetimes, but it can continue on where basically the last surviving executor dies and then has executors who then prove his will. Otherwise, the courts can relinquish it in certain circumstances, but that's fairly rare.
Okay, thank you.
Excellent. Thanks, Ed.
Shandip?
I've got those questions now.
Thank you.
Actually, these are 2 questions related to executors. So I'm going to ask Chetan. First, what does it mean to execute a will? And the second question is, do all executors need to do probate?
Okay, so the meaning of executor will, when I use the word executor will, means making sure it's signed in a valid manner. So signed by the person making the will in the presence of 2 witnesses. That's what I mean when I say executing a will. Sorry, what was the second question?
Second question was, do all executors need to do probate?
No, they don't. So if, let's say there are 2 executors mentioned in the will and one decides to step down or not take an active part, then they can, the person who's going to, the executor who's going to make the application can go ahead, and power is reserved to the other executor. The person who wishes to step down actually has the ability to renounce probate. Just because you've been mentioned in a will as executor doesn't mean it's an obligation for you to comply with to fulfill those wishes.
Excellent. So really, your summary is careful consideration when appointing an executor.
Absolutely.
Okay. All right.
Okay. Ed, a question for you. If probate was not obtained on the first death, on all assets, as all the assets were being jointly held and passed on to the spouse. On the second death of the spouse, or the second spouse, will the probate for the first death, deceased, be required as well? Or is it just basically you avoid having to do the first one, but you just do the second one?
Yeah, you just do the second one. So if from what the question was, basically everything passed by survivorship, or was able to be the bank accounts were able to be closed because the amounts weren't great, no probate is required. There could be one, it's not really a complication, but when you're claiming the unused nil rate band in the second estate, and the residence nil rate band, you just have to produce a death certificate or a copy of the will, if there was one, with an explanation. So you don't have to go back to do the probate of the first death.
Good, great, thank you.
All right, a question for Atul, and I think this may have been partly covered in the presentation. How does one carry out a will search? Is there a national will register?
Right. First of all, there is no central official register. So once a will is signed or executed, you don't have to go and register anywhere. But there is a private register which is open, which is called the National Wills Register, and it's managed and run by a company called Certainty. And you can make a search of that register to establish if there's any entry of a will being in existence. But because it's not a complete register, you need to make other inquiries of the family, friends, previous solicitors, anybody who might have knowledge of existence of a will.
Mm-hmm.
And that together, I would say, is what you would do when you would say register a search or a will search.
Okay, excellent. Thank
you. Chetan, I'll pass this on to you. It's a bit of a loaded question. It's typically, what would be the sort of cost, professional fees cost for probate and filing of IHT returns for a basic estate of, say, £1 million, but not a complicated one. I'm making that assumption because obviously if there are complications, it's a completely different policy.
As you say, it's a loaded question. Yeah. Every firm that is out there will have different ways of charging. Mm-hmm. They may have different charges. So the only thing I can suggest is make your inquiries and find out what firms are charging. Make sure you call about 4 or 5 and take the best possible quote or who you feel comfortable with.
Mm-hmm. Thank you.
Excellent. So actually nicely leading on to the next question on this. I'm going to ask Ed. Question has come up. Would you recommend professionals to do the probate, or would you recommend someone to do DIY or independently?
Well, obviously professional, but that's a bit sort of biased. There's no reason why you can't do it yourself, but you've just got to be aware of the liabilities. There is a penalty regime which HMRC operate through IHT. And we have seen it where executors have been levied penalties where they've been careless or negligent. So it's just about being mindful. And also the other thing is that you're accountable to the beneficiaries. So you need to take into account basically that you need to be impartial, independent, fully disclose all your actions. And some people just don't have the time, or they don't want to get in the middle of that. So you can do it yourself, but having professional assistance, you have that added sort of benefit that you've got somebody impartial, completely independent, professional. They know the pitfalls. Many people only deal with probate once or twice during their lifetime, so you're never really going to become experts. So that's the benefits of getting professional assistance.
Okay.
Can I just add one more thing, that there is no difference in law when you're applying person or through a professional, in the sense that if you get it wrong, you get into trouble. So obviously, to be wise to do it professionally, unless you are comfortable to do it yourself.
Yeah. Okay. Atul bhai, can I direct this one to you, please? If somebody wants to challenge a probate, is there a time limit within which the challenge should take place? It's a two-part question, so I'll ask the second part in a minute.
Ideally, the challenge should be started by writing to the parties concerned, those who have been appointed as executors. But parallel to that, I would suggest that an application or an entry is made in the court called caveat to stop probate being granted to anyone. And the two go in parallel, so that by placing the caveat in the court, it stops somebody bypassing what you want to do, and it opens up negotiations. And while that is happening, obviously you would enter into communications with the executors named in the will or the family and put your case forward. Now, in terms of time, there is no such time that whether you can apply now or later, but sooner you get moving would be in your interest, because if you wait and probate is granted, then obviously it is granted. If there is a caveat placed in the court, then the party against whom the caveat is placed can ask the court to, can apply to the court to look into the caveat and open up proceedings to establish whether the caveat should be lifted. Alternatively, you can take action by questioning the validity of the will and taking it to court. So there are different ways you can approach it. And there is no general way you would look at a case, because it will depend on what exactly is the circumstances of that particular case, how you would go forward, how fast you would go forward, and who you would approach.
Okay. The second part of the question, as I was saying, there is a second part, is obviously if probate is granted, and for what you just said, you probably can't do much once it's granted. But what happens if another will is actually found some years later? In that scenario, is there any recourse to going back and doing something about that?
Yes, there is. Even if probate is granted by the court retains the overriding supervisory role, so that if there is any issue relating to the probate or to the grant or the validity of the will or the will which has been proved, you can always go back to the court and ask the court to look at the circumstances, look at the case. And there are cases where courts have approved the will, probate has been granted, and then later on somebody makes an application saying there is another will, which is a later will, or the previous one is not valid, or whatever the circumstances are, and the courts have revoked previous grants of probate. So it can happen, but again, the specifics will decide how you approach it, what you do, in what time frame you do it. But the possibilities are.
Do the statute of limitations come into play at all?
Well, statute of limitations depend on knowledge of when you became aware of your claim. So then it depends on when you became aware of the fact that there is a second will. So it's much more complicated. The answer in the session.
Yep. Okay.
Excellent.
Thank
that
you.
was quite a heavy question.
Sorry. That was very typically legal question. Is this?
Okay, so I'll make it even heavier now.
Thank you.
So Chetan and Atul, really, I think this is for you, although Ed might be able to let some light on this. So explain more about the marriage certificate by Visha Oshwal, Kenya. Is it valid or not? If not, what is your advice?
Okay, so I'll start with Atul Bhai, and then perhaps you can add in. To be honest, I really do not know what the position is, and I've not been able to get any clear answer as to what the statute in Kenya actually intends to do. I'm not sure whether it is intended to mirror the, say, the Hindu Marriages Act in India, where you can have a valid marriage, you can perform a traditional ceremony. All you need to do is register it. You're still married, even if you haven't registered it. So unfortunately, the answer is I don't know. Atubhai, over to you, in case you know more.
Now, well, if you look at the basics of English law, it's made up of statutory law and case law. Now, there is nothing in the statute which I've come across which would give us a determination as to what should happen. But we also have case law where judges can say that the marriages are valid because of the number of years that have passed, or the actions and the circumstances in which they were done and the intentions of the parties. But at present, up to now, we haven't come across any case where the courts have explicitly decided on that. Now, to avoid complications in the future, the better way is to make a will which deals with the point to make sure that whoever you want to give the assets to are named properly. Instead of saying, I leave everything to my wife, you actually name the person so that there is no question of marriage coming into play. So you can cover yourself without trying to solve the problem which exists at the moment.
Just to add to that, I think there may be further complications because you may lose the spousal exemption if, for whatever reason, the government decides to challenge the wills, saying they're not valid. I've not heard of any similar case of that nature. I've spoken to a barrister who's dealt with a case regarding validity of marriages. There was a recent case of an Islamic marriage which was held not to be valid. So,
Ed, have you had any experience of these kind of issues, marriage?
No, not with Kenya. And when we administer estates, we always ask for the marriage certificates. And a lot of the time, yeah, there haven't been any problems.
Okay. Right. Actually, Ed, this is a perfect question for you. There is a 6 week delay at the London Probate Office. Yeah. Is there any way or any suggestions for getting a probate approved very speedily?
In truth, there's very little you can do. We've had numerous problems over the last 3-4 years. Whenever basically there were threats about the increase in the probate court fees, which created a tidal wave at the probate registry, and we were seeing delays of 3-4 months. So when we tried to sort of argue that we needed the grants, the probate registry were completely deaf to what we were saying. We did get one thing with them in that they agreed that if there was imminent loss to the estate, that we could prove that they had to issue the grant in priority to everybody else's, they would do it. But we didn't satisfy them on that with any of our cases.
Okay, thank you.
Okay, excellent.
Sorry, guys. Before you go on, I just saw a question come in again on the oshawa marriages. Sorry to interject.
That's okay.
Yes, it is correct that the certificates have been accepted for naturalization purposes. They've been accepted for immigration purposes. I fully accept that. It's just not something that I would want to risk.
For probate?
Yeah, for probate.
Yeah, okay. Good. All right, so Chetan, probably an easier question, this one. Is the 6-month deadline from the date of death?
This is for an Inheritance Act claim.
Yeah, or probate, even to do the probate, etc. Is it from the date of death, yeah?
No, it's from the date of the grant of probate or letters of administration.
Right.
Okay. Next question, again, Atul, for you. Can I use a deed of variation at a time when I'm about to become a beneficiary, but I would like the assets to go to my kids rather than me? provided that the other beneficiaries agree. This is basically trying to transfer the assets down the chain rather than actually you receiving them as a beneficiary.
Once a person is passed away and the will becomes effective, there is a period of 2 years within which a deed of variation can be done. And in that process, the beneficiaries can agree to change the terms of the will, and the terms of the will which are changed are backdated to as if they were in the will. So it is possible for the beneficiaries to say that one beneficiary comes out and in that place somebody else comes in. It is possible.
Mm-hmm. Okay.
Okay.
I think, yeah, that one's answered.
Yeah, I've got one for Ed.
Yeah.
So Ed, with the complexity of probate and the responsibility on the executors, would you recommend an indemnity insurance? And typically, how much would it cost? I think the cost is difficult to assess, but would you recommend indemnity insurance?
We never, well, I've never come across people taking out indemnity insurance for acting as executors. I've seen obviously where there are issues with the estate, such as missing beneficiaries. They're not sure about, whether there are, illegitimate children, for instance, where you can go and get a policy to cover the possibility that somebody comes forward, but not. I've never seen people actually do it to cover their own role as executor and any liability on them apart from that.
Okay. Chetan,
Yep.
question for you. What advice would you give to anybody regarding any documents if the UK resident, so a person who is normally residing here, dies overseas?
In terms of documents, do you mean in terms of death certificates? Or
Yeah, and whatever requirements you need to conclude for probate here.
In order to do probate, all you need is the death certificate that has been issued in the country of death. So that should suffice. If it is in a language that is other than English, you would need to have that translated.
Does it have to be a certified translation?
Yes, it will have to be an official certified translation.
Thank you.
Okay. So question here. Atul, this is for you. Why is probate so highly complex? Can it not be made simpler? I think it's for the government, really, that question, not for you, but I'll vote you in next time as an MP.
He doesn't want to lose his business.
I think it also, the reason why we have a process is it also has consequences to make sure that everybody is covered, be it family, beneficiaries, executors, the HMRC, and all that means that there are steps in place. And complexities sometimes come because of the variety of assets, number of assets, clauses in the wills, how you have done the will, or it can be also the question of, as you say, oshawa marriages. It could be anything. So it depends very much on the circumstances, whether probate that you are going to go through is going to be complex or not. Not all probates are complex, as much as not all probates are simple. You'll have a full range between simple probates and extremely complex probate. Extremely complex probate would be where somebody has passed away in Spain, but has assets in, say, India, France, South Africa, UK, and then you're looking at taxes, nationalities, and even resealing and new probates and everything. So it depends on what you have. So in terms of complexities, not all of them are. Some are not. It depends on the circumstances.
So comment has actually come in on the chat on that question. To make probate easy, give away all your assets 7 years before you die, so you don't have anything. So
simple.
Excellent. Over to you, Ramit. Next question.
Yeah. This one to Ed. Ed, is if a probate is not issued for whatever reason, what are the next legal steps that need to be taken to ensure that everything is done properly and sorted out so that probate can be issued or letter of administration can be issued?
So from that, somebody's had a will that they haven't issued the grant for whatever reason, so they've challenged the validity of the will. Then it would basically be for an administrator to step forward and to administer the estate, and that really depends on whether the will is valid or it's an intestacy. So there's an order of priority as to who can apply. And effectively they step up and have the same responsibilities as an executor. That would be the only thing. They would still need to go and get letters of administration in order to administer the estate if that's required.
Okay. Question for Chetan, and Chetan will laugh at this one anyway, but if there's a will with just one witness on it, can it ever be made valid?
No, it can't be made valid. The rules are that you have to sign in the presence of two witnesses who are physically present at the time that you're signing, and both of them have to sign in your presence. So that's an invalid will. Throw it in the bin, get a proper one done.
Okay.
Okay. Very simple question, Atul. If one is an executor, is it, oh, sorry, not that one, sorry, I'm reading the wrong one. If a deceased had one bank account in his own his or her personal name for a small amount, but everything else was in joint names with their partner, and the total estate is obviously less than £1 million or small amount, do you still need a probate?
Well, because most of the assets are in joint names, they can be transferred to the survivor.
Yeah.
With the account which is in single name, it depends on the institution or the bank where the money is, if they will accept a death certificate and maybe an indemnity form to release the money. Some of them allow, some don't. So it may be driven by the bank or where the money is. With joint assets, as Chetan mentioned in the slide, you have to be careful when you're dealing with property, be it a house or a flat. And if it is held as joint tenants, it's fine. If it is tenants in common, then again, the need for probate can arise. So it depends on the bank and how the property, if it is flat or a house, if it is held jointly or as tenants in common.
Okay. Question for Ed. It's a basic sort of question of good practice. Would you recommend prior approval of the executor before appointing them in the will?
Yes, it's always worth notifying a person that you're appointing them as an executor in your will. We've seen quite a few situations where people have appointed people who they thought were their friends or colleagues as executors, but when they've passed away, nobody wants to touch it.
Yeah.
And where families might not be getting on in these circumstances, it's created no end of problems. So yeah, I've personally, I've asked my executors under my will whether they were happy to carry out the role, because you don't want to be in the situation where you've appointed them but they've got no intention of carrying that out.
Absolutely.
Chetan, question for you. What happens if the main property is not owned as joint tenants, but it's tenants in common?
You would then need to get probate.
Yeah. Okay, that's simple and
Simple
sweet.
answers.
That's what I like to hear.
Yeah.
Okay, I'm sorry, just going down. A couple more, and that's it.
Question for Atul: how long is a grant to probate valid for?
I think we asked this question already.
Yeah. There isn't any expiry date.
Is there? No.
And there is a case I came across many years ago where the usual administration was finished within, say, a year, but the grant document remained with the executors. And 20 years later, it was resealed in India to deal with a property they found in India. And that was fine. But it also opened an extra issue that because a new property has been found in India, they had to revise their tax returns and notify revenue here. So the grant can be used later, but not necessarily within the usual time frame of normal administration. Can come in handy later as well.
Okay. All right. Before I wrap up, I've got last question. That's for Chetan. Chetan, if there is only one beneficiary in the will, and that beneficiary has passed away and the will has not been changed to accommodate this, what happens in those circumstances?
Okay, so the first thing is, if there's just one beneficiary in the will, I'll generally look at the clause to see whether it provides for the issue of that beneficiary to inherit. The will has to expressly state that. If the beneficiary has passed away and there's no such provision in the will, then it's the rules of intestacy that will kick in.
Okay, thank you very much. Okay, just before I finish, I must apologize to it. There are a few more questions which we cannot take. Time has actually overtaken us. We just need to wrap up. So first and foremost, a very big thank you to Chetan and Minesh for the fantastic presentations, and also for Atul and Ed to help us on the panel and answering those questions. Thank you. And thank you to Shandip for helping moderate as well. As we said before, this particular presentation has been recorded. We will aim to put that on YouTube shortly. It will take a day or two, so please bear with us. We will also try and look through the question and answer sheet, the questions we've got, and we'll try and answer them at some point, but you need to give us a little bit of time to try and see if we can get those answered so everybody's questions are looked at as well. Nirmal, can I have the slides, please? Thank you. Okay, so before we wrap up, this is our poster to say, you know, we are helping the elderly, the vulnerable, the people who are in isolation, and key workers. So if anybody needs help with medicines, meals, essential shopping, etc., someone to talk to, please call us on this number. And if there's anything else you wanted from today's webinar, please SMS or WhatsApp or our helpline number. And this is the number. So all registered attendees, as I said before, will receive a feedback request after our series of 5 webinars, which is last one's on Sunday. So after that, you'll receive that. So please provide feedback. And also, if you have looked at the videos and seen the videos of the past seminars, the webinars, can you please put a like on those so that the more people who like the videos, the thing comes up further up the chain for people when people are viewing or looking for these. Our next webinar is on social care expenses on Sunday, the 17th of May at 11:30. So please, if you haven't yet registered, please register. We really look forward to welcoming you all on that day. And if you have any further suggestions for future webinars, please email us at cat8webinars@gmail.com. And finally, thank you very much for attending today. Be safe, stay alert, control the virus, and save lives. Goodbye. Thank you.